Hello, Michigan Realtors, and welcome to 2018's first installment of The Letter of the Law. I'm Brian Westron, and today we're going to look at a question that has been recurring in real estate markets around the country. Can a real estate licensee safely work on a transaction that involves property used for the cultivation or sale of medical marijuana? Many realtors are facing this issue more and more, whether as an agent or a landlord. As you might imagine, the answer to this question doesn't boil down to a simple yes or no. In fact, the analysis involves layers of conflicting governmental regulation and frankly requires the possession of a crystal ball to make any definitive determination. Our purpose will be to look at the current landscape and identify the risks that real estate professionals face when working on these transactions. The national climate for legalized marijuana for medical purposes has changed drastically over the last 10 years. Currently, there are 30 states and the District of Columbia that feature some kind of regulatory framework for allowing use and cultivation of medical marijuana. Michigan is one of those states. Michigan is also a state with a tentative ballot initiative underway to decriminalize recreational use of marijuana for individuals 21 years or older. Proponents of the measure are waiting to hear whether the issue will appear on the 2018 ballot. Of course, this installment is not intended to weigh in favor or against the legalization of marijuana for recreation or medicinal purposes. Regardless of how you feel on a personal level, realtors should take great care when offering advice or working on a transaction where the real property's past, current, or intended use involves marijuana sale or cultivation. Based on the current trends, these types of real estate transactions may get more complicated for the buyer, seller, and others involved in the transaction. Irrespective of how the landscape for medical marijuana and/or recreational marijuana continues to develop in Michigan, the undeniable elephant in the room remains the federal government's strict treatment of marijuana as a Schedule I controlled substance under the Federal Controlled Substances Act. This Schedule I designation is important as it does not acknowledge any medical use for marijuana and classifies it as a drug with a high probability of abuse, placing it in the same category as heroin and LSD. As such, the federal law on all marijuana is diametrically opposed to Michigan's allowance for regulated medical marijuana. Now, this conflict between state and federal law has caused a fair amount of confusion and understandable apprehension within the real estate industry. In the last few months, we have seen many, if not all, title and financial institutions, along with their respective underwriters, issue notices indicating an unwillingness to perform closing, title insurance, or lending services for property used or intended to be used to cultivate or sell marijuana. Now, this decision appears to have been triggered in large part by a U.S. Treasury Department advisory bulletin that came out in August of 2017. In that bulletin, the government made clear that financial institutions are required to file a suspicious activity report if they suspect that one of their transactions involve funds derived from illegal activity. While title companies and real estate brokers are not similarly required to file such reports, the government indicated that they are encouraged to do so. There is also a concern on the part of many title companies and financial institutions that any involvement in the closing of a transaction of real property used for the cultivation or sale of marijuana may be viewed as aiding and abetting a criminal drug enterprise and/or money laundering. This concern related to aiding and abetting is compounded by the fact that in January of 2018, there was a significant pronouncement from the United States Justice Department that the previous federal policy of relative non-interference with state marijuana law enforcement has been reversed. As such, there will likely be a period of increased uncertainty as to how federal prosecutors will direct enforcement efforts in those states with some form of legalized marijuana use and cultivation. Understandably, this potential sea change in federal enforcement has triggered conservative and risk-averse positions by title companies and financial institutions. The positions being adopted by title companies and financial institutions create important considerations for realtors. In many ways, it shifts us back to the question posed at the outset of this video. Can a real estate licensee safely work on a transaction that involves property intended to be used for the cultivation or sale of medical marijuana? The answer remains a murky one. While the federal government does not require real estate licensees to file suspicious activity reports, they are specifically encouraged to do so. Taking the legitimate concerns raised above to their logical conclusion, a real estate licensee representing a buyer or seller of real property used for the cultivation or sale of regulated marijuana could arguably be subject to the same type of federal scrutiny. As it stands, the scope of enforcement efforts remains a large unknown. Of course, even if pursuit of a realtor involved in such a transaction may seem somewhat unlikely, should it occur, the cost of defending a federal criminal prosecution is always very costly, both in terms of money and reputation. Even with a crystal ball informing a realtor that he or she could confidently represent a client in these types of transactions without risk, there are still significant issues to consider. A realtor representing a buyer or seller of real property used for the cultivation or sale of regulated marijuana must fully appreciate the burdens of a real estate transaction that may not include the ordinary checks and balances of the title and mortgage process. While there might be a title search conducted, there most certainly will not be title insurance or escrowing of funds. The deal will likely be a cash deal or some form of land contract. Buyers of former marijuana facilities also risk becoming involved in the federal forfeiture process, even if the buyers use the property for a different and wholly legal purpose. In short, in transactions involving marijuana facilities, you will likely be relied upon for areas of expertise outside the scope of your license. For these reasons, not only should a realtor encourage his clients to seek legal counsel, a realtor should consider declining to represent any client who will not agree to use counsel for this type of transaction. As always, thank you for tuning in and watching this first installment of 2018. If you enjoy the letter of the law, please click the above link and explore some new continuing education options based upon the series. If you have questions or would like to suggest topics for future videos, please send those suggestions to the email below. Again, thanks for watching and see you next time.